Welcome to In the Gap. I'm Katherine with the Estate Law Center, and the following is a collection of law articles using personal stories to explain the meaning and importance of estate planning. This is meant to be educational and does not establish an attorney-client relationship. Enjoy the following story. Roadmap for an Executor, 7 steps. The call comes late one evening or early the next morn. Whether a client or an inquiry from a stranger seeking guidance, when I hear the question, "My loved one has passed, now what?" I so wish I could take away the pain, ease the grief. The interruption, there is nothing in life that prepares one for the passing of a family member or a friend. Not only is one grieving the loss of a loved one, often the same individual finds him or herself named as the executor or executrix in the decedent's will. Out of respect for the decedent, the executor will want to ensure that her intent for her estate is honored. The following is a roadmap for the executor, outlining the possible steps to take if you have been named in a will as an executor. Please keep in mind that each will is different, and there may be variations to address or situations that arise that need specific legal advice from an estate planning attorney, an answer from the Commissioner of Accounts, or an opinion from the Circuit Court. The following instructions are applicable to the Commonwealth of Virginia and are not comprehensive or case-specific, nor are they intended as legal advice. Step 1. Qualification of an executor. When your loved one passes away and you have been named as an executor, you may choose to submit the will for probate and qualify as the executor. Prior to submitting the will, you are encouraged to seek legal advice. In the event that the estate is insolvent, meaning the debts outweigh the assets, consulting with an estate planning attorney is critical. To probate an estate in the Commonwealth, you must submit the last will and testament to the Circuit Court of the county in which the decedent resided at the time of death and qualify as the executor. The clerk of the Circuit Court will want the following documentation prior to setting the time for the appointment: the last will and testament, the death certificate, the probate information form, the list of heirs, and the probate tax return. Unless an asset falls within the definition of a small estate, valued under $50,000, and can be handled under a small estate affidavit, it is necessary to probate an estate when the decedent has solely held assets, that is, assets which do not have a joint or co-owner with the rights of survivorship, a beneficiary on the security or account not in the will, or a transfer on death designee. Assets include real property and personal property, both tangible and intangible. Step 2. Attending the appointment for qualification. If the decedent died with a will, having provided the information required under Step 1, in addition to providing the money for the bond or the bond with surety, bring the following with you to your appointment with the clerk of the Circuit Court: the original will and self-proving affidavit, the certified copy of the death certificate, a Virginia resident who can qualify as the registered agent if the executor resides outside of Virginia, photo identification, and cash or check to pay fees, for example, state and possibly local probate taxes. Step 3. Taking on the role of executor. Control. Once you have received the certificate of qualification, it is your duty or authority to take control and possession of the estate assets. Determine what real property and personal property is owned by the estate of the deceased. No commingling of accounts. Obtain an EIN for the estate. Establish a checking account in the name of the estate of the deceased. Investment and diversification. The executor has the responsibility to invest and preserve the value of the principal funds of the estate. Be aware of the governing Code of Virginia requirements, as well as if the prudent investor rule has been waived within the will. Record keeping. Keep precise and accurate record keeping of all assets and any and all distributions, as well as additional items the Commissioner of Accounts may require. Do not commingle any of the estate assets with your personal assets. Notice to heirs. Within 30 days after your date of qualification, you are required to provide notice to all the heirs at law and all the beneficiaries under the will using the form titled Notice Regarding Estate. Within the same time frame, you are required to submit the Affidavit of Notice Regarding Estate. This form is submitted to the Clerk of the Circuit Court. Taxes. The executor is charged with the responsibility of filing any income, inheritance, or estate tax returns required by the state or federal law. Tax questions should be addressed by a certified public accountant who has an understanding of final estate filings. Step 4. Inventory. Within 4 months after your date of qualification, you must submit the completed Inventory for Decedent's Estate form to the Commissioner of Accounts. The assets reported on the inventory are those assets that comprise the estate of the decedent and their fair market or tax assessed value at the date of the decedent's death. Step 5. First accounting. Within 16 months after the date of qualification, you must submit the completed Account for Decedent's Estate form to the Commissioner of Accounts showing the estate transactions for the initial 12-month period. Annual accountings are filed until the estate is distributed. Step 6. Debts and Demands Hearing. In the event that the executor does not have a comprehensive understanding of the decedent's financial encumbrances, it is good practice to submit a request for a debts and demands hearing to the Commissioner of Accounts. Step 7. Show cause against distribution and order for distribution. File a motion with the Circuit Court for a show cause against distribution hearing, allowing legatees or distributees a forum for contesting the distribution of the estate. The anticipated order of distribution that follows such hearing is the blessing from the court to proceed with such distribution. Such order affords the executor a protection against demands of creditors and all other persons as stated in Section 64.2-556 of the Code of Virginia. Seeking advice from legal counsel, a certified public accountant, and a financial advisor regarding estate administration prior to taking any action should reduce the fear or trepidation regarding the probate process. As stated earlier, the above steps are not case-specific. Though each estate matter is unique, the Code of Virginia truly affords protections for both the intent of the decedent and the good faith efforts of the fiduciary. It is my hope that this story resonates with you. The Estate Law Center serves clients throughout the Commonwealth of Virginia in the practice areas that touch most of our lives: estate planning, elder law, and business law. The motto of the Estate Law Center is protecting the stewardship of your God-given assets. Enjoy additional articles read from In the Gap, and for more information, please visit estatelawcenter.com. I leave you with this, and the following comes from my heart. We must protect those who are not able to speak for themselves. We must protect our neighbor who has been wronged by another. We must reach out to the elderly who may be overwhelmed by a vast system of laws. We must act boldly when others may be caused to be weak and use the protective arm of the law to guard against the trampling of individual liberties. Thank you for joining this segment of In the Gap.